Imagine this. It's, I don't know, a Tuesday night, you're on your couch, watching a movie, just minding your own business, and then a heavy knock on the door.
The worst kind of knock.
The worst. You open it, and there's a stranger with a stack of papers. You've been served. You're being sued for massive damages. And you're frantically scanning the paperwork trying to figure out what you did.
Right, your mind is racing. Did I hit someone with my car? Did I breach a contract?
Exactly. But it's none of that. You're being sued because your son, Gary, decided to beat up another kid down the street. And your first reaction is just outrage. You're thinking, wait a minute, I didn't throw the punch. I wasn't even there. Why am I on the hook for this?
It's the ultimate parental nightmare, and you're right to have that knee-jerk, this isn't fair reaction. Legally, this whole problem sits right at the explosive intersection of family privacy and public safety.
I mean, it feels terrifying.
It is. And today, we're not just talking about bad parenting in the abstract. We are going to dissect a very specific, hard-nosed legal doctrine. It's known as parental failure to control. We're going to look at exactly when the law steps in, points a finger at the parents, and says, you should have stopped this.
And how are we going to do that?
We're going to perform a rigorous analysis of a landmark case. It's called Linder v. Bidner, a Supreme Court of Queens County decision from 1986.
Okay, and just to set expectations for everyone listening, this isn't just a story about a fight. We have a mission here today. We want to break this whole doctrine down into its raw components, the general rule, the exceptions, and the actual test courts use. So let's start at the very top. I need the foundational concept. If I have a kid and that kid breaks, I don't know, a window or a nose, am I automatically liable?
The starting point is actually quite relieving for parents, so you can exhale a little bit.
Okay, good.
The general rule is that, generally, parents are not liable for the torts of their children. The mere fact that you share DNA, that's not enough. The parent-child relationship itself doesn't create liability.
So the law doesn't believe in sins of the son visiting the father?
Not as a default, no. However, this is a massive however, a parent is considered negligent if they fail to adopt reasonable measures to prevent a definite type of harmful conduct. This is key, when they have the ability to control the child.
Wait, so if I'm a parent, I'm actually better off not knowing what my kid is up to. That seems completely backward.
It feels backwards, doesn't it? But legally, yes. Knowledge is the trigger. It shifts the whole situation from bad luck to negligence. If you don't know, you can't be expected to prevent it. But if you know and you do nothing, that is where the law nails you.
Okay, definite type of harmful conduct. That still sounds a bit vague to me. If we're going to apply this, we need a really specific legal test. How do judges actually measure this?
There is one. The courts look to the restatement of the law of torts, Section 316. This section basically lays out the boundary lines.
And what does it say?
It says a parent has a duty to exercise reasonable care, to control their child, and prevent harm to others, only if two specific conditions are met.
Okay, let's hear them.
Condition 1. The parent knows, or has reason to know, that they have the ability to control the child. And Condition 2. The parent knows, or should know, of the necessity and opportunity for exercising that control.
Ability and necessity.
Exactly. You miss either of those prongs, if you physically can't control them or you genuinely didn't know you needed to,
Right.
then liability generally doesn't attach.
Right. That seems straightforward in theory, but I can imagine it getting incredibly messy in real life, with teenagers, complicated families.
Oh, absolutely.
So let's transition to the case to test this rule. Let's see how this plays out in the real world. Let's analyze Linder v. Bidner. First, lay out the scene for us. What are the legally dispositive facts?
The facts here are, well, they're painted quite vividly in the complaint, and honestly, they're disturbing. We have a plaintiff, Stuart Linder, who's an infant, which in legal terms just means a minor.
Okay.
He was assaulted by the defendant's son, Gary Bidner. And the assault wasn't just a shove. The complaint alleges Gary assaulted Stuart with his fists. But the critical facts are all about Gary's history. The court documents say Gary had a known vicious and malignant disposition.
Vicious and malignant. Wow. I mean, that is incredibly strong language for a legal document. Usually you hear reckless or negligent. Malignant sounds like a disease.
It's intentional language for sure. The complaint details a specific habit of mauling, pummeling, and assaulting smaller children. And crucially, this was no secret. The parents were notified frequently by complaining neighbors about these attacks.
So they knew.
They knew. But here's the kicker, and this is where it gets really dark. The complaint alleges the parents not only failed to control Gary, but they actually encouraged him.
How do you encourage your kid to maul people?
By resenting the neighbors who complained. When people tried to admonish Gary or resist him, the parents got angry at the victims, at the witnesses. And Gary saw this, so he felt empowered.
Unbelievable.
And there's one more vital fact we have to flag. This is the twist that makes this case famous. At the time of this assault, Gary was 18 years old and employed.
Hang on, 18. Then how is this even a case? If my 18-year-old punches someone, that's on him. He's a legal adult. I can't put him in timeout anymore.
You would think so, right? That was the parents' entire defense. But the complaint alleges he still lived at home and was subject to their control.
Okay, so that's a complex fact pattern. You've got an 18-year-old mauler living at home with parents who hate the neighbors. So what was the core legal issue?
The issue is whether the parents can be held liable for Gary's assault, given their knowledge of his specific vicious habits and their failure to control him. Especially in light of the fact that Gary, might be considered emancipated because of his age.
Okay, and what rule of law did the court apply here? Please state the full black-letter rule and break it down into its testable elements.
So the court applied the rule from Restatement Section 316, which we just talked about, and they backed it up with New York precedent, a case called Zuckerberg v. Munzer. And the rule effectively has three distinct, testable elements that a plaintiff has to prove. You have to hit all three.
What are they?
First, ability to control. The parent must have the power to control the child. Second, notice of specific propensity. The parent has to know about a specific dangerous habit. And third, failure to act. The parent must have defaulted on their duty to restrain or discipline the child.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. Let's start with that first hurdle, which seems like the highest one given his age. How did the court apply the first element, ability to control?
This created a fascinating sub-issue. Can parents legally control an 18-year-old son? The defense, they argued heavily here. They said, look, Gary is 18, he's self-supporting, he's employed, he's emancipated, therefore we have no legal ability to control him.
And that sounds like a pretty solid argument. At 18, the law usually cuts the cord.
It's a strong argument for trial, absolutely. But, and this is so important, this was a motion to dismiss. We're not at the actual trial yet. The judge is just deciding if the victim's story is legally possible.
So at this stage, the judge has to assume everything the victim says is true.
100% true. So the court held that whether a child is truly emancipated is a question of fact that has to be decided at trial. Since the complaint alleged that he lived at home and was subject to their control, the court had to accept that as true for now.
So just because they gave him a place to live, that was enough?
Exactly. Even at 18, if you live under my roof, eat my food. I have leverage. I have ability to control because I can kick you out. So for this stage of the case, element 1 is met.
Understood. The court basically punted on that issue, saying, we'll decide later. Okay, now what about the second element, notice of specific propensity?
This is where the court drew a very, very sharp line. The sub-rule here, and they lean on a famous legal guide called Harper and James for this, is that the dangerous habit must be of a very specific kind.
A very specific kind.
Right. There's no liability for what the law calls general incorrigibility. You aren't liable just because you raised a brat.
So just being a bad kid isn't enough. If my kid is just generally unpleasant, I'm safe.
You're safe.
Huh.
The law doesn't want to police general parenting. But here, the application of the facts was just damning. The court noted the parents had full knowledge of Gary's specific habit of beating up smaller children.
And how did they know that for sure?
Because the neighbors had frequently told them. This wasn't just Gary being rude. It was a predictable, repeated pattern of physical assault. So the court found this element was clearly met. The parents knew of the necessity to act.
Predictable pattern. That seems to be the key phrase there. And finally, the third element, failure to act or restrain.
So the sub-rule here comes from a case called Excelsior Insurance. And the court held that parents don't need to, isolate or lock up a child unless the risk is that extreme. The duty is defined by the risk reasonably to be perceived.
So it's a sliding scale.
It is. A broken window is a low risk, low duty. A mauled child is a massive risk, massive duty. And applying it to Gary, the court looked at that risk reasonably to be perceived. Given his history of prior antics mauling children, the risk was incredibly high.
So did the parents do anything?
Nothing. The court found they did nothing. No guidance, no admonition, no control. They allowed him to go at large among children. And worse, by resenting the neighbors, they arguably made it worse. So that element was met. They defaulted on their duty to society.
And after analyzing all the elements, the ability to control, the specific notice, the total failure to act, What was the court's final conclusion?
The court denied the parents' motion to dismiss. The judge ruled that the complaint validly stated a cause of action. It sufficiently alleged that the parents knew of the dangerous propensity, they had the ability to control it, and they failed to do so. The case could move forward to trial.
It's a powerful ruling. It really pierces that veil of he's just a kid or, he's 18, not my problem. I want to go back to something you mentioned, that difference between specific propensity and general incorrigibility. I feel like that's where a lot of people might get tripped up.
Agreed. It's the nuance that decides these cases, the difference between a dismissed case and a huge settlement.
Okay, let's use some hypotheticals to make this really visceral. Hypothetical one. Let's call this the general brat. You have a teenager, he's rude, don't clean his room, talks back, smokes behind the garage. A problem child. One day, just out of spite, he sticks his leg out and trips a neighbor. The neighbor falls, breaks a wrist. Are the parents liable?
The result there, no parental liability.
Really? But they knew he was a nightmare.
They knew he was rude and difficult, sure. But they didn't know he had a specific propensity for physically tripping people. This falls squarely under general incorrigibility. The law doesn't punish you for failing to instill manners. You can raise a jerk, legally speaking. You just can't raise a weapon.
A weapon. Okay, that's clear. Now, hypothetical 2. Let's call this the bat wielder. This is based on that Zuckerberg case you mentioned. You have an 8-year-old kid who has a known habit of swinging baseball bats at people. The parent knows this, but lets the kid keep the bat and go outside unsupervised. The child hits a housekeeper with the bat.
Liability attaches, 100%. This is the textbook example. The parent knew of a specific dangerous tendency, swinging bats at people. The bat, in this child's hands, is a dangerous instrument.
And they could have just taken the bat away.
They could have just taken the bat away. They had the ability, they had the notice, and they failed to act. It's a direct line of negligence.
That makes the specificity requirement crystal clear. It has to be the same type of danger. Okay, hypothetical 3, the passive enabler. This is basically our Linder case. Parents know their son beats up kids, neighbors complain. The parents don't discipline the son. Instead, they scream at the neighbors, call them snitches, and slam the door. The son hears this, thinks mom and dad have my back, and goes out and does it again.
Result?
No.
Liability, absolutely. This is Linder v. Bidner in a nutshell. It's actually worse than just a passive failure. It's getting closer to active encouragement. The court in Linder was particularly disturbed by that allegation that the parents resented the admonition of others.
It's like they were sending him a signal.
Exactly. It signaled to the child that his behavior was acceptable. When you know about a danger and you block the community's attempt to protect itself, you are assuming the liability for whatever happens next.
It really highlights that the law expects parents to be society's first line of defense. If you drop that ball, the law steps in.
Precisely. The court even used that kind of phrasing, that the parents owed a duty to society to guard their son. It shifts it from a private family matter to a public safety duty.
Okay, we've covered the rule, the deep dive into Linder, the hypotheticals. I want to bring this all home for the listener. Whether you're a law student staring down an exam or just a nervous neighbor, let's synthesize this. What's the diagnostic checklist?
Okay, if you're looking at a fact pattern and trying to spot this issue, you need to run this 4-step exam kit. Think of it like a flowchart.
All right, step 1.
Step 1, the control check. You have to ask, is the child a minor? Or, if they're older like Gary, are they living at home under parental rules? And the answer is no. If they're fully emancipated, living on their own, stop, no liability. If yes, proceed to step 2.
Step 2.
Step 2, the specificity check. Look at the bad behavior. Is the past behavior a specific dangerous habit, biting, hitting, arson? Or is it just a general bad attitude? The law requires that definite type of harmful conduct. If it's just general nastiness, you probably don't have a case. If it's specific, you proceed.
Step 3.
Step 3, the notice check. This is critical. Did the parents actually know or have reason to know about that specific habit? Did the school call? Did neighbors complain? If they were genuinely in the dark, they can't be negligent. But if they had notice, you go to the final step.
And the final step.
Step 4, the reasonable care check. Did the parents take steps proportionate to the risk? Did they discipline the kid? Confiscate the weapon? Warn others? They don't have to lock him in a dungeon, but they have to do something proportional to that risk. If they did nothing, or worse, encouraged it, liability attaches.
That is a powerful framework. It turns a messy family drama into a clear legal equation. As we wrap this up, I keep thinking about the parents in the Linder case. They probably thought they were protecting their son by yelling at the neighbors.
They probably did, thought they were being loyal.
Exactly. But in the eyes of the law, that loyalty was actually negligence. It suggests the burden of parenting isn't just about, feeding and clothing your kids. It's about protecting the world from them when you know they're a danger.
That is the core takeaway. We think of parental duties as flowing down to the child to nurture, to support. But Linder v. Bidner reminds us that the duty also flows outward, to the community. When you bring a human being into the world and you see they're causing harm, you don't get to look the other way. The privilege of raising a child comes with the obligation to make sure they don't become a hazard.
A sobering thought for anyone with kids or neighbors with kids. So next time you see a kid acting out and the parents are just looking the other way, you'll know they aren't just being bad neighbors. They might be walking right into a lawsuit. Thanks for diving in with us.